Hello and welcome to BiteSize Law. So this is the first in a series of videos on formalities and constitution. Today I'm going to take you through some introductory concepts and explain what we mean by formalities. Then I'm going to look at the formalities relating to a declaration of trust, which will involve us looking at the Law of Property Act 1925, section 53 1b. Then, as you can see, I will then move on to look at constitution, the principle in Milroy and Lord, the exceptions to Milroy and Lord, and then finally I'm going to draw it all together by taking you through some short examples. Incidentally, if you find my videos helpful, please consider subscribing to my channel and like and share, as it really does make a difference. So the first thing I want to do is to briefly look at what we actually mean by formalities. I'm sure that you're aware that the law often requires property owners to comply with certain requirements when they're dealing with their property. So, if a property owner wants to transfer ownership of their property, they may have to do it in a prescribed way in order for the transfer to be effective. And if they don't do it in the correct way, then the ownership doesn't transfer as they had intended. So formalities are simply legal requirements. So legal formalities apply to many transactions in relation to property, and particularly in relation to land. So they are rules which are imposed either by legislation or case law. And they prescribe how you must do something, so they relate to the form that you must use. So, as a property law student facing a problem on formalities and constitution, you will often be required to work out what the relevant rule is in order to advise a property owner on how to achieve what they want to do. Or probably more likely, you have a scenario where you're told what a property owner has done and you need to work out the consequences of those actions. Did the property owner achieve what they intended to do or not? So in order to work out the relevant rule or the law that you need to apply, there are two things that you need to consider. The first is what was it that the property owner intended to do with their property, and the second is what type of property is it. So let's just quickly look at some examples to illustrate this. The first is a will. Now here the type of property isn't relevant because a will covers all types of property. The intention of the property owner is to set out what is going to happen to his property when he dies. And the formalities are that the will needs to be in writing and signed, and the signature must be witnessed by 2 witnesses. And if this isn't done, then the will is void. In other words, it's completely ineffective. Another example is the transfer of legal title of shares in a private company. Here, ownership has traditionally been evidenced by the company issuing a document known as a share certificate to the owner, known as the shareholder. So the shareholder must fill in and sign a document known as a stock transfer form or a share transfer form, which is in a prescribed form, and send it to the company. The company directors may have to approve the transfer, and then the final stage is that the company amends the name of the shareholders on their records. And it's at this final stage where the legal title transfers. Up until that point, the property owner remains the legal owner of the shares. In relation to the land, there are, as you would expect, various different rules which apply. So in order to create a contract over land, it must be in writing and signed and contain all the terms. If you want to transfer your legal title to an estate in land, then you must do that by a conveyance, which is a deed, and the registration requirements at the land registry must be completed. And then finally, if you want to declare a trust over your land, then, as we'll see shortly, that must be evidenced in writing and signed. And did you notice that some of those transactions couldn't be completed without the actions of a third party? So the transfer of legal title to land isn't completed until the proprietorship register of the title has been changed at the land registry. And similarly, the legal title to shares in a private company doesn't transfer until the company has amended its register of shareholders. So sometimes the final stage is outside the control of the property owner, and this can cause problems which we'll see later when we look at constitution. So why does that matter? Well, just consider a couple of examples. Ada executes a share transfer form and then dies before the company registers the change of ownership. Or in another situation, imagine that Barry writes, "I'm transferring ownership of my factory premises, which is land, to my nephew Neil," and he signs it. But Barry is then declared bankrupt, owing his creditors £500,000. And the reason it matters is because in those situations you want to work out who was the beneficial owner of the property. The usual scenario you'll be asked to advise on in an assessment or to discuss in a seminar perhaps is that the property owner has attempted to dispose of an item of property they own, and then he or she either dies or becomes bankrupt, or maybe they simply change their mind. And you have to decide whether the property passes under the terms of their will, or if the trustee in bankruptcy can use that property to pay off the bankrupt's debts, or who can claim the property if the owner has simply changed their mind. If the property owner successfully transferred his or her ownership or successfully set up a trust over the property, then they're no longer the beneficial owner, and it won't form part of their estate when they die, and it can't be made available to his or her creditors if they become bankrupt. Now, you may have come across this in a different context. Don't worry if you haven't come across these cases yet, but you very well may have done. You may have come across the case of MacPhail and Dalton, which was a case involving the beneficiaries of the late Mr. Baden's will trying to argue that a trust that he'd set up during his lifetime was invalid. And if the trust was invalid, then his property would go to the beneficiaries of his will. But if it was valid, then it was held on trust for the objects of the trust who were described as his employees or their relatives. And you may have come across a situation relating to commercial trusts where there may have been some uncertainty over the intention of the company when it received money from its customers. So you might have come across the case of Fairpack, or you might have come across the case of Recayford. And in these cases, the issue was whether the company who had received its customers' money was holding that money on trust for its customers, so the customers were the beneficial owners. And when the companies went bust, so when they went into insolvency, if they were holding the money on trust, then it wasn't available for the company's general creditors to share out to pay off the debts. And you may have come across the case of Paul and Constance, which involved certainty of intention, and the argument there was whether Mr. Constance had declared a trust over some money which he'd placed into a bank account in his sole name. Mr. Constance then died, and his wife was claiming that the money in the bank account belonged to her because she was the beneficiary of his estate, and his longtime partner was claiming that Mr. Constance held the money on trust for her when he died, and therefore it didn't form part of his estate. So when you're looking at a problem based on formalities and constitution, you'll frequently go through these steps in order to work out the answer. So you'll be looking at what it was that the property owner intended to do with their property. Then you'll be looking at the relevant rules or formalities to achieve that intention. Then you're going to check to see whether those formalities have been complied with. So you look to see what the property owner actually did, and then that will allow you to conclude whether the transaction was valid or not. And what you'll see is that there are two stages that might require some form of formality. The first stage is any formalities required in order to declare a valid trust, so whether the declaration of trust itself needs to be in writing. And the second stage that you might need to consider is the formalities to actually transfer property to the trustees of a trust. So in the second stage, as we've just seen, it may require the property owner, the settlor, to complete a particular document and submit it to a third party in order for ownership of the property to pass to the trustees. And it's this second stage which is referred to as constitution. So what we're concentrating on in this video is the first stage, the formalities relating to the process of declaring the express trust. So in relation to formalities for declaration of a trust, it's really simple. There's land and then there's everything else, formerly known as personalty. So to declare a trust over a property which isn't land, you don't have to use a particular format. Think of Mr. Constance in Paul and Constance declaring a trust over the money in his bank account. There was nothing written, there was nothing signed by Mr. Constance. But as you can see, if the declaration of trust is over land, then there is some formality which is set out in the Law of Property Act 1925, section 53 1b. And here's a tip: if the property owner intends to declare a trust, so you've looked at the facts for evidence of the settlor's intention, and you've concluded that he intended to declare a trust over his property, and you are satisfied that the certainty of subject matter and certainty of objects, then deal with the declaration of trust. Don't try and deal with it at the same time as dealing with the second stage, which is whether the property owner needs to transfer ownership of the trust property to his trustees. Always deal with both stages separately. So if you have a declaration of trust over personalty, such as shares in a company or money in a bank account or jewellery, this can be done orally, so you can deal with this issue very, very quickly. If the trust property is land, however, we'll see that there's a little bit more to it. But if it's personalty, then it can be dealt with really quickly. Just state the evidence of the intention from the fact and conclude that the declaration is valid, and then move on to look at the issue of constitution. So now let's have a look at the formalities or legal requirements to declare a valid trust over land in a bit more detail. And just to note that we are only looking at an inter vivos or lifetime declaration here. If a property owner declares a trust over land in his will, then the declaration itself will satisfy the formality requirements. So here is section 53(1)b, and let's break it down into bite-sized pieces. And the first thing to notice is that the first part of the section tells us the type of transaction and the type of property that the section applies to, and that's highlighted in turquoise there. And then the second part, highlighted in yellow, tells us what the formalities actually are. So in terms of the first part, when does it apply? Well, it states that it applies to a declaration of trust. And what type of property does it apply to? Well, it states that it applies to land or any interest therein. So the first part tells us when the particular formalities must be complied with and the type of property to which it applies. And the reference to and any interest therein means that it applies to any interest in land. So, for example, it would also include declaring a trust over an equitable interest in land. Now, I can't stress the information on this slide enough. Please note that section 53(1)b only applies if the trust property is land and it only applies if the property owner is declaring a trust over their land, and that's when section 53(1)(b) becomes relevant. So next we have the words must be. So here we know that the requirements are coming up, and it states that the declaration must be manifested and proved by some writing, and it must be signed by the person who is able to declare the trust. So let's have a look at that in a little bit more detail. The first thing to note is the declaration doesn't have to be actually in writing, so the evidence can come at a later date. Let's have a look at a couple of examples to make this a bit clearer. The declaration on the left-hand side there, Dear John, this is to confirm that from now on I am holding my holiday home Seaview on trust for you, which is signed by the property owner. Now that declaration of trust is in writing and it's signed, and so it will comply with 53(1)(b). If you look at the one on the right hand side, this is to confirm what I told you in the pub last week. I am holding Seaview on trust for you, and again it's signed by the property owner. So here the original declaration itself was made last week, and it was made orally. Now at that point section 53(1)(b) hadn't been satisfied, but when the property owner confirms the declaration of trust in writing and signs it, then the formalities have been complied with. And then the next part of the requirements are that it has to be signed by such person who is able, and this means effectively the beneficial owner, and note that it can't be signed by an agent. So just to confirm, the section doesn't say that the signature has to be witnessed, so a signed letter will do. And you can see an example there on the slide. That letter would comply with section 53(1)(b). So just to recap, section 53(1)(b) applies when the property owner intends to declare a trust. It applies when the property is land, and the requirements are that there must be some evidence of the trust in writing, and it must be signed by the beneficial owner. So here's just a very quick checklist. Check the subject matter, is it land? Because if it isn't, then 53(1)(b) doesn't apply. Check the intention, what is it that the property owner wants to do? Are they wanting to declare a trust over the property? If the answer to that is yes, then 53(1)(b) is going to apply, and then what you would look at to see whether the requirements have been satisfied. So here's a common theme to problem questions on formalities and constitution, and this is the first stage, and the issue you're trying to work out is whether the property owner is or was, if they've died or become bankrupt, the beneficial owner of the property. So you want to know whether the property owner disposed of their property, and in order to do that you find the relevant rule and check to see what the formalities are for that type of transaction and that type of property. Then you're going to be applying those formalities, so you're going to look to see what the property owner actually did, and then finally you're going to conclude whether the intended disposition was valid or not. So if the property owner didn't dispose of their property in the way that they intended, you'll then go on to look at the consequences of that, which is something we're going to be looking at later. So here's a very straightforward example. A property owner declares that he's holding all my shares in BiteSize Law Limited on trust for my children, and we want to know whether he has to comply with any formalities when declaring the trust. The answer to that is no, because the trust property is personalty, it isn't land. Compare that with this one. I declare that I'm holding my holiday cottage Seaview on trust for my son Ben. Does the property owner have to comply with any formalities? Yes, he does, because he's declaring a trust and the subject matter, the type of property, is land. So here's some final points just to remember. 53(1)(b) requires evidence in writing, which is signed by the property owner, but it doesn't state that you must use a deed. So any writing signed by the property owner will comply with section 53(1)(b). The other thing to note, and this is a common mistake that students make in exams, is that it doesn't apply to the transfer of legal title to the land. And if that needs to be done, you need to look at that at the second stage. So for that you need a deed.